All right. Well, good morning, everybody. Again, my name is Tom Hubrick. I am the president of Hubrick Resources, and we are absolutely delighted to have all of you with us here today. Given the robust number of people who signed up for this event, obviously FMLA and ADA are challenges that are shared by many of us. So again, we're happy to have you here. So today we are co-presenting our session, Navigating FMLA and ADA, What Every Employer Needs to Know, with our valued partner, Tompkins Insurance Agencies. And Hubert Resources has partnered with Tompkins for about probably 9 years now. And we have a program with Tompkins where Tompkins offers any of its clients 5 hours of free HR support through our firm, as well as a highly discounted rate thereafter. So if you are a Tompkins client on this call, be sure to utilize that benefit that's available to you. And if you are another employer who might be in the market for insurance, you might want to check out our friends at Tompkins because they do an absolutely spectacular job. We have our very own Denise Garman, who is a senior consultant with our firm. Denise has over 25 years of HR experience and specializes in quite a few things, for everything from doing employee handbooks, policies and procedures. She does leadership training, HR audits. She does fractional HR support for clients and as well as interim HR roles for clients if they have a vacancy within their department. So, without further ado, welcome to today's presentation, Navigating FMLA and ADA, What Every Employer Needs to Know. So, go ahead and take it away, Denise.
So welcome. It's great to see everybody here joining us for this important topic today. These laws are essential in protecting the rights of employees while also protecting and guiding employers in how to respond appropriately to leave requests and accommodation needs. Understanding and properly applying these laws is not just a legal requirement, but it's critical for you as employers to maintain a fair, respectful, and compliant workplace. So before I dive into the materials, just want to share with you that Hubrick Resources provides human resources consulting and recruiting services and does not provide legal advice or representation. The information provided in this presentation is based solely on expertise and knowledge gained through experience and education in the HR field. Our consultants are not attorneys and they do not practice law. Attending this Hubrick Resources training program does not create an attorney-client relationship and should not be viewed as a substitute for securing legal advice. So with that said, our agenda today, I'll be providing some overview of the FMLA law as well as ADA, and then we'll also touch on some Pennsylvania specific laws around leave as well as New York laws. And then we'll also talk about some benefit considerations to keep in mind as you navigate these leaves of absence. So let's start with FMLA. Regarding FMLA, you have to have 50 or more employees within a 75-mile radius in order for this regulation to apply to you, as well as be a private employer, public agency, or a school, regardless of the size. It does provide 12 weeks of unpaid job-protected leave for eligible employees. So the key to that is that it is unpaid, although as an employer, you can offer it as a paid leave. And by protected, we mean that the employee's job must be held while they're off and they must return to a same or similar job. Now, one of the pieces to keep in mind with this is the key employee clause in the FMLA regulation. This doesn't come up often, but if you have an employee who holds a key position within your organization, say, for example, a senior leader, some type of executive role, a higher level role that's really critical to the operations of your organization, if they're considered a key employee, sometimes you may be able to waive that job protected piece because you may need to move forward and replace that job sooner than the 12 weeks if that job is critical to the organization. This type of leave may be taken continuously or on an intermittent basis, and the employee's health insurance is also maintained during that time. Regarding eligibility, the employee must have worked for the current employer for 12 months, not necessarily consecutive. The 12 months can be spread out over several periods of employment. So for example, if you have an employee that worked for you for 6 months, they left your company and then returned and worked another 6 months, they would still meet that 12-month requirement. And then the other prong to this is that they had to have worked at least 1,250 hours in the last 12-month period, and that does need to be consecutive. So you do need to look at both of those pieces to determine whether or not the employee is eligible for the FMLA. Some qualifying reasons for FMLA: the birth or care of a newborn child of the employee, placement of a child for adoption or foster care with the employee, serious health condition of the employee, or a serious health condition of immediate family member, which is a spouse, child, or parent, or a qualifying exigency leave due to an immediate family member on active duty or being notified of an impending call to active duty. Now, under the FMLA, there is also a military caregiver leave, which is a type of leave that allows an eligible employee to take up to 26 work weeks of leave in a single 12-month period to care for a covered service member who has a serious injury or illness. And the piece to keep in mind with this is that the family definition is a little broader. It's not just spouse, son or daughter or parent, but it's also next of kin, which is defined as the nearest blood relative. So that could be a situation where maybe you have a niece or nephew in that circumstance, and you might be identified as the next of kin, and so you may qualify for that military caregiver leave. Intermittent leave is also a component of FMLA, which I think is the one that probably creates most of our concerns as employers. It is a protected right under FMLA. Medical certification is still required for this type of leave as well. And employers may request scheduling cooperation. So if an employee is requesting intermittent leave to attend physician appointments, for example, you can work with that employee and request that they try to schedule those either outside of work or as late in the day or early in the day as possible to not be disruptive to their schedule. Employers must track this leave in the smallest increments allowed. So if your payroll system tracks to every 15 minutes, then that is how you would track your intermittent leave as well. And you cannot deny or retaliate based on that use of intermittent leave also. In addition, this can apply to both the employee and their eligible family members, so they can take that intermittent leave for their own health condition or the health condition of a family member that fits that definition. Recertification may be and really should be requested periodically. As an employer, it's always recommended that you have some type of schedule that you're requiring that. You can't request that any sooner than 30 days, but you may want to have the employee recertify on a regular basis. So for example, if you have an employee that has an intermittent leave for migraines, you may want to request them to recertify at least every 6 months or at least once a year. In those circumstances, the recommendation would probably be at least once a year to ensure that they're still in need of that intermittent leave. You can temporarily transfer an employee. So if that intermittent leave is going to create some type of hardship from an operational standpoint, you could temporarily transfer that employee as well. And this can run concurrently with paid leave, both the intermittent and full-time leave. So you can require the employee to use their paid leave in addition while they're taking FMLA. And intermittent time does not extend to the 12-week limit of FMLA. So if someone goes out for surgery of some sort and they use 6 weeks of leave, that means they only have 6 weeks remaining in that leave year if they then need an intermittent leave as well. Some other things to remember. If an employee misses 3 consecutive days, you need to determine if an FMLA qualifying event exists. So the employee may start off by calling off each of those days. They may not have shared with you the specific reason, but once you get past that 3rd day, you really do need to determine that. You may want to send the FMLA paperwork out to the employee if they continue to be off outside of that 3-day window. And if you don't designate it as FMLA, that time does not count towards the maximum entitlement of FMLA. So you may want to look at your process for that and making sure that you're staying in tune, whether it's your HR department, making sure that supervisors are alerting HR or whoever administers your leave when they do see an employee hit that 3-day mark. If an employee is missing work for the same reason on a regular basis, that could also qualify as an intermittent leave for maybe a chronic health condition that either they're dealing with or a child is dealing with. An example that I encountered recently is an employer had an employee who was taking off every Wednesday to take a child to an appointment. They hadn't really shared the details. The supervisor was allowing them to do that. They could be flexible. And they had done it for several months and then come to find that they learned that the employee was taking off to take the child to a medical appointment every Wednesday afternoon. And so that time could have been counted as FMLA. And so they then did initiate FMLA paperwork once they found that out. But when you see something like that happening, you can certainly say to the employee, hey, we want to make sure that this isn't is or isn't qualifying for FMLA to protect you and us, and then provide the paperwork to the employee to identify whether or not that is a qualifying leave. Some other key points, there is no undue hardship exception to FMLA. So, if an employee requests that FMLA, we need to abide by that and offer that leave. Temporary transfers to a vacant position are only available for that intermittent leave for those planned medical treatments. And performance expectations may need to be adjusted if significant absence occurs. So, for example, if the employee takes a full leave and they're out for the full 12 weeks, and there was a project that they were expected to complete during the course of that time, obviously you're going to want to make an exception, adjust the deadline perhaps that you're holding the employee to, because they weren't there to complete that work or to be held accountable for that work. You cannot contact an employee's healthcare provider directly without their permission. So this is something to be careful of. You want to always work through the employee for those types of requests. Now, if you're questioning the legitimacy of the note, is this actually a true physician or healthcare provider? Maybe there's something about the documentation that raises a concern. You may reach out to the provider at that point just to validate that that is their signature or their office stamp on the paperwork, but you cannot reach out directly to ask specific questions about the medical condition and so forth. If there's something that needs clarified, maybe you can't read handwriting and things of that nature, it's always best to work through the employee so that they're aware you're reaching out, and have them be accountable and responsible for following up and getting you that clarification. So again, if the employer has that honest belief that an employee is taking a fraudulent leave, you may terminate the employee. Again, you want to investigate that thoroughly. You want to proceed with caution. Don't make that decision lightly. And it's always advisable to consult legal counsel in those situations, just because you don't want to be in a situation where then it creates another legal issue. But if there is a legitimate thing that you can prove that the person is fraudulently, trying to take a leave like that, then termination may be appropriate. The other piece that you want to think about are some of those things to do to protect yourself as an employer. So making sure that you require and track the timely return of certifications. With FMLA, the employee has 15 days to return that healthcare provider certification. Sometimes they do come up against challenges with the physician's office or the healthcare provider's office being able to meet that deadline, and they need to make sure that they're communicating that with you timely. So you may have some wiggle room there. You may want to help work with the employee in that situation. Maybe they can't get it to you in 15 days, but they can get it to you within 20 days. But you want to make sure that you're doing a good job of tracking that when you gave the form, what the deadline is, checking in with the employee. If you're at day 13 or 14 and haven't seen it yet, circle back with the employee to make sure that they're still going to be able to get it to you timely. As an employer, you can also request a second or third opinion if necessary. Again, if you feel like there's something that's just not sitting right, or you feel like you need that additional information that is part of FMLA, that you can request that. You can ask for that clarification. So if the healthcare provider provides documentation on that form and you're just not quite clear on, for example, with the intermittent leave, the extent of that leave or the frequency, you can go back to the employee and have them have the healthcare provider provide some additional information. Again, authenticate any healthcare provider if it is suspicious. So that's something that you can reach out to validate, and requiring that recertification routinely. So when you have someone on that intermittent leave, doing that to protect yourself so those leaves don't kind of go on into infinity without checking back in to make sure that they're still necessary. Some other things is discussing and verifying the leave with the employee. When the employee reaches out and shares with you that they may need a leave, have some open dialogue. You want to be careful not to discuss the medical condition itself, but rather focus on the time needed for the leave, any resources that the employee might need, and so forth. Using surveillance or investigations when necessary. Again, if there's something suspicious that's going on, that may be something you use. I've not encountered that too often in my career, but there are times where that may be appropriate, again, if you feel like the employee is doing something fraudulent. Social media is also another consideration. I'm sure some of you may have dealt with the issues where an employee is calling off intermittently, but then they're posting online that they're at the beach or they are out shopping for the day, whatever it may be, and their coworkers are seeing that and then sharing that back with you. And so those are things to navigate carefully, reaching out to your HR department or a resource like our firm to help you navigate some of those tricky situations. Making sure that you clarify the call-off policy for the employee, especially with intermittent leaves. Who should they be calling off to? How far in advance would you like them to call off? Now, also keeping in mind that the employee might have a medical condition that doesn't permit them to follow the normal call-off policy. So perhaps your call-off policy is to call off at least 2 hours before their shift begins, but maybe they have a situation where they get migraines, they come on suddenly, and it might come on 30 minutes before their shift. And so they're not calling off within that window. That also should really be delineated on the healthcare provider form, how the medical condition, that onset might be at the last minute, those types of things. And then be clear about the return to work notification as well, with both full-time leaves and intermittent leaves. If that intermittent leave is coming to an end, when that's closing out, if the employee's on a full leave, when do they expect to return? Who should they be notifying when they're ready to return? And then documenting all of that appropriately. So I want to do just a little test your knowledge. These are just questions for you to think about, and we'll talk about the answers. I'll share those. So the first one is true or false. An employee was hired in November 2024 and is requesting an FMLA leave today to care for their ill parent. You must grant them FMLA time. This would be false. They have not fulfilled that 12 months of service. So remember, you have to think about both the length of service and then how many hours that they've worked. But this person hasn't even met the first one. They've not met the 12 months. Next one, an employee with 5 years of service has a chronic back issue and periodically misses time off from work for a few hours each day. This could be considered intermittent FMLA. This is true. The length of service is long enough. Again, you want to make sure that they have worked that 1,250 hours in the past 12 months, and it is a qualifying medical condition. Next, a supervisor mentions that one of their long-term employees is going to be off for gallbladder surgery. The employee must request FMLA leave from Human Resources to be eligible for the leave. This is false. So you're now aware as the employer of a potentially qualifying leave. So following up with the employee is key. So the employee doesn't necessarily need to initiate that request. If you become aware or suspect that there could be a potential need for a leave, then you need to initiate that paperwork if the employee hasn't already done so. But the employee isn't required to actually say those words in order to be eligible. Next, an employee had a baby in January 2025 and used 6 weeks of FMLA. They have now requested to use the other 6 weeks this summer. You must grant the FMLA leave. So this is true. Under the Family Medical Leave, eligible employees are entitled to up to 12 work weeks of unpaid job-protected leave in the 12-month period following the birth of the child. So that includes the bonding time as well. So the employee used 6 weeks, then are requesting to use another 6 weeks for the bonding, and that can be taken intermittently or in separate blocks of time, but it must be completed within that 12 months of the child's birth. So for the bonding leave, the employer can require, though, that be taken in a continuous block. That's certainly your choice if you want to do that intermittently. So if the employee comes back to you now and says, look, I want to take off 2 days a week over the next several weeks, you don't necessarily have to grant that, but you would have to look at requiring them to do it in a block of time if you would prefer that they take those additional 6 weeks altogether. So that, again, that's one that sometimes employers aren't always aware of, and maybe struggle a little bit with navigating. So next, let's talk about ADA. Obviously, ADA has a lot of interaction with FMLA. This can be, and it can also be standalone and not necessarily in conjunction with FMLA if the employee isn't eligible for FMLA yet, but may be eligible for that protection under the ADA. So the ADA defines a disability as a physical or emotional impairment, which substantially limits a major life activity. It's a federal law that applies to employers with 15 or more employees. And in Pennsylvania, the PA Human Relations Act covers employers with 4 or more employees. So pretty much any employer in Pennsylvania needs to abide by these rules and regulation. It protects both job applicants and employees, so there's no length of service requirement. And the origin of the disability does not determine their right to the ADA. So the employee doesn't have to have this disability from birth. It doesn't have to be work-related. It could be for any reason. Some other requirements of ADA, you may not take adverse action because of a current, prior, or perceived disability. You must make reasonable accommodation unless an accommodation imposes an undue hardship, and we'll talk a little bit more about that. And a reasonable accommodation requires employers to modify how the essential functions of the job are performed. And so we'll talk a little bit more about what that means as well. And that's really why it's important that you have job descriptions for all of your positions that include what those essential functions are. So when someone does, if and when they make a request for an accommodation, you can go to that job description and see what are the essential functions. Some ADA reasonable accommodation examples could be reassignment of non-essential functions. So an employee unloads trucks for 1 hour a week and is no longer able to do so. That probably wouldn't be considered an essential function because it's not really taking a lot of their time. It's not a key part of their job. Flexibility of scheduling for certain positions could be one. So for example, an employee tends to get headaches early in the morning. They suffer from migraines. It's difficult for them to work the 7 to 3:30 shift, but they can get to work by 8. That's more reasonable for them. So their work could be flexed, so you can adjust their schedule. Purchasing or modifying, having equipment that modifies the employee's job to help them perform those essential functions. For example, maybe they have a back issue, and so having a standing desk or a desk that moves up and down that allows them to sit and stand throughout the day as they need to could be a reasonable accommodation. Redesigning of a work area to make it more accessible is always an accommodation that you want to look at. For example, maybe an employee is using a wheelchair, and so you need to reconfigure or build something special in their work area to allow them to get in and out of that area with a wheelchair. Now, you do want to think about the reasonableness of that. So, for example, if making the modifications to that work area is going to cost your organization $20,000 and you're a very small employer, that could be a hardship. But if you're a large corporation, that $20,000 is not going to be viewed as a hardship. So it's really dependent on the organization and each situation. The other thing is a temporary leave of absence. So offering the FMLA or any type of leave of absence is an accommodation in and of itself. And so you want to look at, is the employee eligible for FMLA? If not, what other type of leave? Is there a separate medical leave that I can provide? Maybe they haven't been with you long enough to be eligible for FMLA, but they're asking for several weeks off, and you need to review whether or not you're able to accommodate that. In most cases, that would be considered a reasonable accommodation. What isn't a reasonable accommodation would be eliminating essential functions from the employee's position. So if they cannot do certain essential functions and they're asking you to remove them completely, that would not be considered reasonable. Lowering the quality or quantity of production standards is not reasonable. You do not have to create a new position for the employee. Providing the employer with a new supervisor is not a reasonable accommodation. Excusing a violation of a uniformly applied conduct rule that is job related and consistent with business necessity is not a reasonable accommodation. So for example, if an individual has a mental health concern and they have an anger management issue that's related to that, and they tend to kick maybe equipment or they're damaging equipment out of frustration, that would be something you can't excuse. So it's not a reasonable accommodation to allow the employee to behave that way. Some other ADA considerations, medical information must be kept confidential, and that's the case with FMLA as well. Again, you want to make sure that you're discussing the accommodation and not the medical condition itself when you're having those interactive conversations with the employee. And we'll talk a bit more about what that interactive conversation involves. You also want to determine what is a reasonable accommodation based on those specific circumstances. So every individual's situation is going to be different. So just because you accommodated one employee in a particular situation, another employee's situation is probably going to be completely different. Their role may be completely different. And so you want to really evaluate each one on a case-by-case basis. Certainly you want to look at the precedents that maybe you've set in the past with other employees if it is a same or similar job, but you really want to evaluate each one on its own merits. You also want to eliminate any requirement for a full release and instead ask for that release for the essential functions of the specific job. So this is where, again, it's important to have those good job descriptions that outline essential functions. You want to make sure that when you are providing the ADA, we'll talk about the ADA questionnaire here in a minute, when you're providing that document to the healthcare provider to complete, that you send along a copy of the job description so that the physician or healthcare provider can see what are those essential functions that they need to be reviewing and evaluating as they're determining, what are those restrictions and what they can and can't do. Some other ADA considerations regarding hardship. The employee cannot, or the employer cannot claim hardship based on fears or prejudices towards an individual's disability. Sometimes employers are concerned, obviously, about what the team is going to think or how the team's going to react to those situations. And that's where it's really important that you're coaching employees to be accepting of those situations. So you can't claim a hardship based on the views of others. Cannot claim a hardship based on the accommodation possibly having a negative impact on the morale of other employees. Again, sometimes those situations are difficult. Coworkers see employees calling off perhaps or missing work. And so it does create some maybe hard feelings, but that's where it's important as a leader that you're coaching the employee. Oftentimes I'll say to an employee, you need to put yourself in the shoes of that employee. If you were in a circumstance where you needed an accommodation or you were dealing with a serious health condition, you would want to be treated like this as well. You would want others to, be able to work with you and understand that. And so sometimes having them kind of think about, putting themselves in that individual's shoes helps with that piece. You can claim hardship if the reasonable accommodation would disrupt other employees' ability to work. So again, if there's a circumstance where it's really going to affect operations, productivity, all of that needs to be evaluated and documented really clearly if you're trying to claim that as a hardship. Some other piece to consider is remote work considerations. Given how our workspaces have changed over the past 5 years since the pandemic, remote work seems to come up more and more often, especially in situations where an employee may want an accommodation to work from home. So there's several things to think about as you evaluate those types of requests. One is the ability to supervise the employee adequately now that they're not in person with you. How are you going to navigate that? The use of certain equipment or tools that can't be used remotely. So if their job requires the use of specialized equipment that's only on site that can't be put in their home, that's another thing to think about. Is there a need for face-to-face interaction and coordination of work with coworkers? How important is that to their job? What about in-person interactions with outside colleagues? So for example, if it's a sales position or a business development position and they are required to go out and meet and greet with clients and vendors and so forth, is working remotely going to be able to achieve that goal? And then access to documents or other information located in the workplace. So maybe you have a lot of paper files that individual needs access to. Is it reasonable to transition them into an electronic format for them to have access to, or are there other things at the workplace that they physically need to be there to access that's going to be a challenge if you have them work remotely? So you really need to think about all of those considerations if that comes up as far as working remotely. One of the things to keep in mind is the direct threat exception to ADA. So an accommodation is not required if it would pose a direct threat to the health and safety of the employee or to coworkers. So as the employer, you bear the burden of proof related to that significant risk of substantial harm. So you need to be able to prove what that direct threat would be. That decision must be based on the medical evidence that you've received from the employee, as well as any kind of evaluation that you've done of the workplace, and that there is no way to reduce that risk of harm to an acceptable level. So if you're not able to really reduce that risk of harm, and there is that direct threat that exists, then refusing that accommodation may be appropriate. So let's do a quick check of our knowledge again. So true or false, an employee works on the production floor and it is the company policy that employees are required to stand while filling containers. Allowing the employee to sit down is a reasonable accommodation. So this is true as long as there is no safety hazard. If the production line is fast paced and workers are moving quickly up and down the line, someone sitting down on a stool or chair could be a tripping hazard or impede production work. So that's all examples of things that you would need to consider in determining whether or not it really is a reasonable accommodation. The next one, a business office employee had a serious car accident and can now only work from home. Allowing them to work from home would be a reasonable accommodation under the ADA. So it's true if the role is appropriate for remote work. So again, you need to consider how the essential functions of the job would be impacted. So reviewing that job description, looking at what those essential functions are, and can they reasonably be completed working remotely? What is the impact on the work space by having them work remote? What do they have access to? What don't they have access to? So all of those things that we just talked about in the previous slide. Next, the administrative assistant's role requires her to spend over 50% of her time on the phone. She has a hearing impairment that makes hearing on the phone difficult. She is asking to eliminate phone work from her job duties. Is this a reasonable accommodation? False. Answering the phones is an essential function of her position. So you need to engage in that interactive process, which again, we'll talk about in a little more detail here in a minute, in order to discuss how to accommodate that hearing issue. Maybe there's something you can attach to her phone to help with her hearing, maybe special equipment that she needs. Is there a special headset, for example, to help her so that she can work with that issue that she's got? The next one, behavioral expectations outlined in the company code of conduct require employees to treat each other with respect and dignity. An employee's mental health condition causes them to have bouts of anger and hostility, and they in turn lash out at coworkers, creating an uncomfortable work environment. You need to accept this behavior and coach the employee through it as a way to accommodate their condition. So this is false. Employees are still expected to follow your policies and procedures and behavior expectations, regardless of their disability. So you would want to handle this through the coaching process first, like you would any other employee, and have that interactive conversation with them to see, why those issues are occurring, how you can help them navigate them perhaps. But if they are creating that type of uncomfortable work environment, you're still okay to coach and address those. So the interactive process is a key piece to the ADA. And as an employer, you need to show that you take the employee, work with the employee, and take them through that process. So having good documentation as you navigate this process is also important. So to kind of step through this, so the employee requests, or perhaps you become aware of an ADA accommodation need. You want to make sure that you're responding promptly and beginning that interactive dialogue in good faith, and then have the employee's healthcare provider complete an ADA questionnaire. If that's something you don't already have, that's certainly something that we in our organization can provide and work with you on as well. But it's a detailed questionnaire that they would then take to their healthcare provider, where they would answer questions regarding whatever their limitations are, the frequency of perhaps the issues that they're having, and so forth, to help guide you in determining whether or not you can reasonably accommodate. So then you want to analyze the job to determine its purpose and essential functions. Again, already having that job description in place is going to be important. You'll want to consult with the employee regarding the nature of their disability and their precise limitations based on the questionnaire responses. Again, you want to be careful that you're not talking about and asking questions specific about the condition, but rather about what the restrictions are and what their needs are. And so then you want to work with them to discuss and identify any potential accommodations. So when you're having those conversations, encourage the employee to bring some solutions to the table. You yourself should be brainstorming some of those as well, so that you can talk about all of the different options with them. So you'll want to solicit and consider their preferences. That doesn't necessarily mean that, what they prefer what the final result on that. We want you to provide some solutions. We may or may not be able to accommodate your specific solution, but we want to hear ideas that you have. And then assess those for undue hardship. Are the ones that they're bringing forward, that you're bringing forward, what level is the hardship related to those? And then select an effective accommodation. Again, it may not necessarily be the one that they've brought forward. And then you want to notify the employee and implement it promptly. And then provide any training if there's some additional training perhaps that they need because you've modified their job in a particular way. And you want to make sure that you are documenting this process at every step along the way, making sure you're dating things. When did you meet with the employee? What was the dialogue you had? And even following up and writing with the employee. Once you make that decision, drafting a letter explaining, based on our conversation on X date, here was what we agreed to as far as your reasonable accommodation. Here's the expectations of your job and so forth. And then once that accommodation has been put in place for some time, check back in with them, maybe within the week, the first week, after the second week, and just have a regular routine of checking in and making sure that that accommodation is working the way that you wanted it to, that you were both hoping it would. I just want to mention briefly, I'm not going to get into a whole lot of detail, but workers' comp can also interplay with both of these. So one thing to consider is perhaps counting FMLA concurrently with workers' compensation leave. So you are permitted to do that. Some employers make the choice not to, and that's certainly your prerogative as an employer not to. The benefit of counting it concurrently is if an employee goes out on workers' compensation leave for a period of time and you have counted it concurrently, then they may exhaust that FMLA, which means that if they return and in another couple of months they go out for surgery, they're now not going to qualify for FMLA. So it protects you as the employer from that employee again going out on another extended leave of absence. Again, it's based on whatever the philosophy of your organization is around whether or not you want to count that concurrently. And then you do want to consider any ADA interplay with the workers' compensation injuries. So, for example, when you have an employee who's ready to return to work, maybe in a modified duty position, kind of going through the same process of talking about what is a reasonable accommodation, what can you do to accommodate that work-related injury, because now they're protected under ADA as well. So I want to touch on some specific state laws and city laws that have come up. Keep in mind that every state, city, county could potentially have their own leave laws or sick time laws and so forth. So if you are an employer that operates in multiple locations throughout Pennsylvania or multiple locations throughout other states, you want to make sure that you're doing some good research or engaging, a firm like ours or a law firm to help you navigate that. This can be very challenging. Some laws have a variety, or some states have a variety of laws that you really need to be able to navigate. And so it's important that you're, looking into that and following all the necessary regulations. So the first one I want to point out to you is Philadelphia, and I'm sharing that because I believe some of our folks that are on the call today operate in these areas. But Philadelphia, the city of Philadelphia, has its own paid sick leave law. So this applies to employers with 10 or more employees. They must provide paid sick leave. If the employer has 9 or fewer employees, they must provide the leave, but it would be unpaid. And then employees who work at least 40 hours a year in Philadelphia can earn this sick leave. Now, there are some that are not eligible that you see listed there, like independent contractors, seasonal workers, and so forth. So it's not applicable across the board. So you'll need to think about that as depending on the type of employer you are. But the covered reasons for this leave is for the employee's own health needs, to care for a family member. And this, as you see, the definition here is broader than FMLA. So it's children, parents, spouses, grandparents, grandchildren, siblings, and life partners. Or it could also be due to a domestic abuse or sexual assault situation as well. So a little different than the FMLA. And employees can earn 1 hour of sick leave for every 40 hours they work, up to a maximum of 40 sick leave hours may be earned in the calendar year. This time can be used after an employee has worked a minimum of 90 days and may limit the amount of sick leave an employee takes in any calendar year to 40 hours unless the employer provides more. So in some cases, the employer might provide in excess of that. But the thing to keep in mind here, an employee is eligible for this once they've worked a minimum of 90 days. So again, this is different than FMLA. So if you have employees that in the city of Philadelphia, they would be eligible for this even before they would be eligible for FMLA. It is paid at their regular rate, and a carryover is permitted into the next year unless the employer provides at least 40 hours of sick leave at the beginning of each calendar year. So some employers may choose to just front load that time versus it accruing over time. They do have the choice to do that as well. Now I want to transition and talk about some laws in New York State. So New York has what they call a paid family leave, or PFL. Employees working for private employers with one or more employees after 26 weeks of employment are eligible for this. The covered reasons for this leave is to bond with a newborn, adopted or foster child, or to care for a family member with a serious health condition, not the employee's condition, but for a family member, and to assist loved ones during a family member's military deployment. So this is up to 12 weeks of paid leave, and it is paid at a percentage of the average weekly wage up to a state maximum. So there is a schedule around that. Some things to keep in mind with this one as far as how it interacts with FMLA. This leave can run concurrently if the reason qualifies under both. So as you saw in the previous slide, some of the family members are different, but some do overlap. And then the employer must inform the employee when the leave is designated as both so that the employee is aware of what it's being counted towards. And then employees are entitled to the benefits of both laws, including the job protection and the health insurance continuation. So it's similar to FMLA in that regard. Now, the coordination with other benefits also needs to be considered here. So if the employer also has a short-term disability plan, that cannot be used concurrently with that PFL. However, employees may choose to use their STD first and then their PFL, ensuring that the total leave does not exceed 26 weeks in a 52-week period. Accrued paid time off, if the employer offers PTO, employers may permit employees to use PTO during PFL, but they can't require it. And then another one to point out to you that went into effect in January of this year, if you're not already aware of this, that New York mandates at least 20 hours of paid leave for prenatal medical appointments. So this is separate from PFL and cannot be used concurrently with it. Another type of leave that New York has is called paid sick leave. So this is PSL. All private sector employers in New York State, this applies to all of them. The employee accrues 1 hour of sick leave for every 30 hours worked. The leave entitlement here is based on the net income and the size of the employer. So if it has 5 employees or fewer and a net income of less than $1 million, it's 40 hours of unpaid. If it's 5 employees or fewer and net income of greater than $1 million, then those 40 hours are considered paid. If it's 6 to 99 employees, then the 40 hours would be paid. And if it's 100 hours or 100 employees or more, then it's 56 hours of paid leave. So this can be used for the employee or family member illness, for preventative care, and certain public health orders. So unused PSL does carry over each year, but that usage cap applies that is referenced above. So with benefits eligibility during leave, it's really important that you are navigating that alongside the leave itself. And it's especially critical for self-funded plans. So if you are an employer that offers a self-funded plan, it's especially important for you. So you want to consider when benefits end for the employee on leave. So for example, when the employee reaches the end of their FMLA and they exhaust that leave, that benefit eligibility technically ends as well. And so you want to make sure that you are offering COBRA in a timely fashion, communicating with the employee about the end of their benefits as well, and being proactive about that. So as the employee is approaching those situations where they're going to exhaust those different leaves, reaching out and having those conversations so that the employee isn't caught off guard at the end of that time. You also want to make sure that any HR policies and practices that you have in place align with your summary plan descriptions for your health plans. So for those of you that have an open enrollment that happens in the fall, you're probably already starting to talk about any benefit changes and things of that nature. So making sure any changes that you make to those summary plan descriptions now are reflected in any HR policies and practices that you have, so that all of those things align. Again, making sure COBRA is initiated timely when that benefit eligibility is exhausted. And when you do discover an issue, make sure that you are reaching out for assistance as soon as possible, whether that's to your specific HR partner or to your broker, such as Tompkins, for those of you that may be a Tompkins client, so that they can assist you in walking through that process. So as we wrap up today, I just want to share some takeaways with you, things to maybe put on your to-do list and think about as you walk away from today's training. Communication is so important as you navigate these different leave scenarios. It's important that you're informing employee about their rights under the leave laws, having open communication as the employee is going out on those leaves, returning from those leaves. Keeping those lines of communication open so that, again, the employee isn't caught off guard by anything that may be happening related to, their employment status or their benefits. It's also important that you have proper documentation. So making sure that all the leave requests are documented, any follow-up communication that you're having is documented. Sometimes the best approach is maybe just to keep a log of all of your communication. So if you've had a phone call with the employee, start kind of keeping a log of the date you talked to them, what you shared. Maybe you're doing email follow-up communication with them, confirming what the conversation was that you had. So really keeping good documentation of all of that, so that if the employee says, well, hey, I never got this communication, or I wasn't clear about this, you can go back to that paper trail of communication and documentation to help clarify things. Policy development, you want to make sure that you do create and maintain clear leave policies that comply with all of these regulations, whether they're state or federal requirements or different local requirements that you have. Having those good solid policies in place are going to help you administer all of this much easier. I know some employers, even outside of FMLA and ADA, you may offer a separate personal leave or a separate medical leave for those that aren't quite eligible for FMLA. Having those policies in writing is important as well. I've worked with employers who don't necessarily have all of that detailed out, and they handle it kind of on a case-by-case basis every time someone makes a request. And sometimes that can be challenging, especially if, again, you're not keeping good documentation of those scenarios. But having those rules in place. So, for example, if you're going to offer a separate personal leave for employees when they don't meet FMLA eligibility, outlining what that is, that you're going to approve up to 4 weeks of personal leave in a 12-month period, or whatever that may be for your organization. But having that documented in a policy or in your handbook is important so that employees know what benefits are available to them, and then they know how they work if and when they need to access them. And then training is also important. Training your leaders in the nuances of these leave laws is important to ensure that they're complying with them in their day-to-day roles as a supervisor, and that all of those leave situations are being administered properly. So the training for them may not go into as much detail as we did today, but they need to understand the basic obligations that you as the employer have under FMLA and under ADA, so that they're having appropriate conversations with employees about that. That they're answering questions that they can answer, and directing people to the right resource when there are questions that they can't answer, so that they're not misspeaking when they're trying to navigate these situations as well. So training those leaders on a regular basis about all of these pieces is important also. All right, so I think we have some time here. We have about 10 minutes. We can open it up to questions. And if you need to drop off the call and you want to put your question in the chat, you can do that as well, and we will get back to you with an answer.
All right, thank you, Denise. I am going to open up our Q&A section of today's webinar. And before I do so, I just want to point out that Tom Hubert shared in the chat, it's important to keep in mind that an employer is subject to the employment laws and regulations of each state, county, and city where the employee resides, not just where the employer is located. This has become especially important with remote workers. For example, if a New York company has employees who live in Pennsylvania, the employer must comply with the employment laws of Pennsylvania for those employees. This applies at the county and city level as well. So I just want to point that out. That was in the chat. We have a lot of great questions coming in, and that came in during the webinar. So this is very exciting. Denise, if you could field some of these, and Tom, feel free to jump in as well as needed. So we have a question. Can we reach out if we need a note to return to work because it was not clear or included on the FMLA documents? And that was Sue. So Sue, I'm not sure if you're still on. Are you referring to reaching out to the employee? So this is regarding a note to return to work because it's not clear. I'm assuming, Denise, and in my experience, they would mean reaching out to the physician. So can they
Right.
reach out to the physician because it's not clear about a return to work?
Yeah, the employee needs to provide that return to work note, so the employer should be requesting that from the employee. If the employee has not provided the appropriate return to work note, then you should not return them, because that could potentially open you up for other issues. For example, if they've been on an FMLA for 12 weeks because of maybe they had knee surgery, you'll want to make sure that they are fully released to return to work and you have that note in place, because if they return to work without that note and then injure themselves, now you have a workers' comp claim. So it's really important that you have the employee provide that note, and not allow them to return to work until they have provided it.
Great. And we have another question. Is there a minimum number of days the employer must wait before reaching out for recertification?
So you can't request a recertification any sooner than every 30 days. The only exception to that might be if the employee really had a change in their medical condition within that period of time, but that happens fairly rarely. So it's usually you cannot ask for it any sooner than every 30 days. The thing to keep in mind with those recertifications, again, like I mentioned earlier, with the intermittence is it's important to, as an organization, decide how often, what's the minimum amount of time that you're going to require those. So for example, that person with migraines, is it every 6 months? Is it every 3 months? I mean, you want it to be reasonable. But if there is a change in their condition, so for example, maybe their original release says that they may call off up to 2 times a month, and now they're calling off 5 times a month for the past couple of months, then you could provide that recertification form to the employee and request that they have it filled out again, because it appears as though their medical condition has changed. And so you want to make sure that you have the appropriate documentation in place. So even if your policy rule is that you're going to require it at least every 6 months, you could request it sooner, maybe at the 4th month, if you see that their medical condition has changed, or if you see a pattern. So for example, if that employee tends to call off every Friday, or every day after a holiday or a long weekend, you're starting to see that pattern, then that would be an opportunity to request a recertification from the physician. Often what I recommend employers do is draft a cover letter to the physician, with the certification attached, explaining why you're requesting the recertification. That, I've seen a pattern in their call offs. This is the pattern I've seen, or, the original certification said 2 days a month. In the past 2 months, they've been calling off 5 days. And, we're concerned that maybe their condition has changed and would like an updated certification. So sometimes that gives the physician or the healthcare provider some background.
Great, thank you very much. And just to, if you did speak to this, Denise, we're just going to reconfirm it. For qualification purposes, must the employee complete 12 months of employment and 1,250 hours?
Right, they need to complete both of those. So, yes, yeah. So in that one example that I gave, the employee hadn't done even the 12 months. So we didn't even need to look at the 1,250 hours because they hadn't reached the 12-month threshold yet. So they do need both of those then in order to qualify for FMLA.
Okay. And we have a question, and I'm not sure if this might be another topic for another webinar, so I don't know if we want to touch on this. We can always get back to the person who posed this question, and that is, do we have any guidance on medical marijuana cards?
Yeah, I'll speak to that real quick. Yes, that is an entirely different webinar. However, for the person who posted that question, we'd be happy to have an offline conversation with that person and answer any of the questions they may have. But that's yeah, that you go down that rabbit hole, and we'll be here till dinner time.
Yes. And Hazel had a very great question regarding an ADA accommodation around an emotional support animal. And if Hazel, if you're still on, I just want to let you know that we will reach out specifically to your situation regarding the questions that you posed in the chat. With regard to, allergies of the pet, additional breaks, that's something that we will reach out to you specifically regarding this question around liability if an animal bites another employee. So we will reach out to you, Hazel. And Angie has a question. How does it work for married couples who work for the same employer? I did ask for some additional information on that for details. So Angie, I'm not sure if you are still with us or not regarding if you could specify how does what work, or if you're able to read into that question, Denise.
Yeah, and it may be back to the, oftentimes this comes up with leaves for a child. Like if
Yes,
they
I'm
had
sorry,
the,
they
had the
did,
birth of a
sorry to
child.
interrupt. It says it was for FMLA childcare issues. Yes.
Yeah. So with the birth of a child, obviously the medical portion is just the mother, but then the bonding portion, that is a combined amount, a combined 12 weeks. So the when you get into the intermittent piece, that's where I'd probably want to talk offline and just understand the specific situation. So I'm happy to reach out to you directly, Angie, to talk about your scenario.
Yeah, great. And those are, Stephanie asked, what if a remote accommodation is given and it is causing turnover of existing staff? So it sounds like, maybe there's some issues there that others have a remote accommodation and on-site employees do not, and it's causing turnover. So that might be something we can address with Stephanie offline as well.
Yeah, that one
Yeah.
sounds a little deeper. Yeah.
Yeah. So Stephanie, we will get in touch with you regarding your question. And I think those are all of the questions. We have one more. In keeping medical information confidential, does every member of the HR department need to be informed of the details of an employee's FMLA request, or are they only allowed to be informed of the accommodations?
So with your HR team, I would limit it to those that need to know, that are involved with that employee's particular situation. I don't know how large your HR team is, but for example, if you have a recruiter and that is their primary job, I would think they would not need any access to information about an FMLA or anything of that nature. So, and the medical information specifically really should be kept confidential. A supervisor should not see those certification forms. Even the return to work notes and things of that nature, the supervisors really don't need to see. Those should go somewhere central, where in HR or with whoever administers HR in your organization, so that all of those medically related documents are kept very confidential. So it really is a need to know basis as far as the medical information itself, and really is those that are making the decision around whether or not the leave is qualifying for FMLA or understanding the ADA situation. And again, when you're talking with the employer, when the supervisor is talking with an employee, it's really about the accommodation itself and shouldn't be a discussion about the medical condition, asking them details of, oh, when did you start first having that condition, or how are you feeling? How does it make you feel? You shouldn't really get into any of that detail. It's more about the job and accommodating the work around that.
Great. Great. Thank you. We have a few more here, and we're more than happy to stay on as they come in. Nancy is asking if an employee has a child and has 6 to 8 weeks of disability leave, does FMLA pick up after the disability leave is over?
So I'm going to assume you're Pennsylvania when you're asking that. So if not, then we can have a separate conversation because it's a little different. But if you offer a short-term disability benefit, the employee can utilize that benefit while they're on FMLA. So in that case, it does run concurrently. In New York, it works a little differently.
Thank you. And Denise, what are examples the employer could use to work with an employee that does not meet the FMLA requirements but needs to take time off? So what are some accommodations that you could make to provide them some leave without meeting FMLA requirements?
Sure. So this would be an example of that personal leave that I mentioned earlier. So a lot of employers do offer some type of personal leave or personal medical leave for those employees that may not yet be eligible for FMLA. Again, you want to make sure that you have some specific requirements around that. A lot of employers that offer those types of leave still require a similar type of healthcare provider note. Obviously, you want it to be certified that it's legitimate that the employee needs that time off. You want to require that return to work note when they're able to return. But you as the organization need to make a decision on what's the time frame that you're going to allow. Is a personal leave permitted, up to 12 weeks as well? Are you going to permit a full 12 weeks? Is it 8 weeks? I've seen that vary depending on the organization. So that's more of an internal conversation for you as an organization to decide what you want that to look like. But again, it's important that you document and have a written policy and guidance around what qualifies for that personal leave and what doesn't, and what the timeframes are, and then the documentation that you want to make sure you're keeping in conjunction with it.
Okay, great. Thank you. I am answering some questions that were posed in the chat that we will provide separate offline conversations. And I just want to remind those who are valued Tompkins clients that you receive with that partnership 5 free hours of HR support services from us here at Kubrick Resources. And we are more than happy to speak with you and help answer these questions. If you're not a Tompkins client, we're still happy to help you and answer questions. So I do have names of who posed questions in the chat, and we will reach out to you directly. I do have your names, your email addresses, and we'll shoot an email over to you with our contact information to get those conversations started so that we can have further discussion regarding some of these very detailed questions that you're asking. I know that some people are asking for additional guidance on leave of birth of a child, specifically in New York. We can certainly get into that with them. But if we're getting a lot of thank yous as well, and this was very helpful, extremely beneficial. So I'm going to put my email in the chat, and anyone who is interested in having further conversations and help and guidance, especially with New York. New York is a tricky one, and Denise is very up to date on compliance regs and laws up there in New York State. So we're more than happy to have Denise work with you and any of our consultants as well. Just so you know, the webinar was recorded, and we will provide a PDF of today's slide deck as well. So we will be sending that out within the next 24 hours. And thank you so much, Denise, for such an informative, detailed, informational webinar today.
You're welcome. Thank you all.
Yeah. Yeah, so just real quick for those who are still on the call, again, we thank you so much for being with us today, and we're happy to answer more questions. Just feel free to reach out to us, and keep us in mind. We'll be doing other webinars throughout the year, so we'll include you as well. So I hope everybody has a great rest of your day, and thanks again. Bye.
Thank you.